Hello, and welcome to the Canadian Story, where we discuss what Canada is, what Canada could be, and what Canada should be.
Hello, everyone. Thank you for being here, and welcome back to the Canadian Story. Today, I am joined by Mr. Marty Moore. Marty, welcome to the show.
Thanks, Zach. Good to be with you.
It's good to have you here. So, Marty, go ahead and tell us about yourself. I'm really looking forward to this conversation. I think it's going to be an important one. So, what's kind of your background? What do you do? And who are you working for?
Yeah, well, I grew up on the prairies here in Western Canada, in Alberta and then Saskatchewan. I decided to go to law school and was excited about that. Actually went to law school in the United States, practiced in Chicago a little bit after I was called to the bar, and then came back to Canada. And upon returning to Canada, did a year at the University of Saskatchewan, started hearing rumors about this organization called the Justice Center for Constitutional Freedoms. In fact, my high school debate coach was there working for them. And I thought, wow, constitutional freedoms in Canada. What a thought. Let's check this out. And wouldn't you know it, ended up volunteering with them when I was in law school, then articled with the Justice Center, and have now worked with them ever since 2014.
Okay, cool. I read your bio over before we did this and saw that you studied in California. Where in California were you?
Yeah, my law school was based in California. I actually was living and working and studying in the Chicago area. And so the degree came out of California, but I was in Oak Brook, Illinois. Gotcha.
How was Chicago for you? I've been there numerous times.
Yeah, I mean, it's a great city. I enjoyed it. I could, be critical of the way the politics works in Chicago. I could be critical of, I think a lack of integration, a lot of pretty stark divides based on backgrounds, whether you're north side, south side Chicago. But there's a lot to be loved about the city of Chicago for sure.
It's got a great culture, but I do have a few choice opinions about Lori Lightfoot, I must say.
Well, there's a long line before her as well. So
yeah.
If I lived in DuPage County, which is a separate county from Cook County. But once you start getting into the Cook County zone, the stories are pretty hairy, and unfortunately, a lot of them are true when it comes to the cronyism, et cetera, going on down there.
Yeah, I believe it. So the JCCF, the Justice Center for Constitutional Freedoms, it has, I realized just a few minutes ago, quite a bit more history than what I thought. I fell into this idea because I discovered it during COVID, that it started during COVID, like many other organizations we've seen pop up across the country. But it's older than that. So how old is it, and what kind of litigations did it engage in before all of this COVID stuff came up?
Absolutely. Yeah, the Justice Center was founded in 2010 to defend the constitutional freedoms of Canadians. And, I think it's not a surprise that, people like yourself and others weren't as familiar with the Justice Center, because many Canadians have taken their constitutional rights and freedoms for granted for a long time, or even been unaware that there were Canadian constitutional rights and freedoms. But the Justice Center has been fighting in the realm of constitutional law since 2010. Cases such as free speech cases on university campuses. The Justice Center published something called the Campus Freedom Index, where we saw a real concern that was beginning on campuses, university campuses across the country, where rather than engaging in good faith debate, there was a movement to really shut down and censor the views of those that people disagreed with. Now, the initial cases came as more like pro-life cases, people talking about the right to life for the unborn, unpopular opinions that were getting shut down. And then, there was a creep broader than that as well into, you want to talk about men's issues? Well, we're a feminist campus. You're not allowed to talk about those issues. You're going to have to leave campus. You're a threat to me based on what you talk about. And these were issues that we saw. So we litigated those issues. We saw, for example, in 2020, after a good half decade or more of litigation on college campuses in Alberta, that the Court of Appeal of Alberta said the Canadian Charter of Rights and Freedoms applies to university campuses in Alberta. So we saw the right to free speech actually respected. That was a pro-life case out of the University of Alberta. So we've been on that path. That's one of the many paths that of constitutional rights defense the Justice Centre is engaged in. There's the whole issue of religious freedom and whether or not government entities can, shut you down or demand you change your beliefs or how you express your beliefs in order to access government services. The Canada Summer Jobs Program, for example, your audience, maybe you're familiar with what happened back then when we saw the Trudeau government tell Canadians, everybody's allowed to apply for the Canada Summer Job grants, except those that will not attest to our view of abortion rights and our view of sexuality rights. And of course, the idea of compelled speech in order to participate in a government program was very concerning. We filed a case against that. The government reversed that program. The next year, we saw discrimination go underground, where there was a clear attempt by the government to weed out organizations that they viewed as having disfavorable beliefs from that program. We took that case to court, won it. And actually, the court in that case ordered solicitor-client costs against the government for its actions in regard to the Canada Summer Jobs Program and the litigation that they were pushing, in this case, against summer camps that we represented.
Okay. So what does that mean? Because you used terminology that I didn't understand.
Sure. Thanks for stopping me on that. Yeah.
I'm not going to even be able to repeat it. You used terminology about, I guess, the defense in this case having to do something. What were they ordered to do?
Right. Okay. Yeah. So what happened is we challenged the government for denying a summer camp access to the Canada Summer Jobs Program on the basis of the government's belief about this camp's religious beliefs. And when we litigated that case, we won the case. The court said you were unfair to this camp. Your decision was unreasonable to deny them access to this program. And in response, the judge hearing the case said, not only am I going to find in favor of this camp, I'm also going to order that the federal government pay a punitive measure of legal fees toward this camp because of the conduct of the federal government in regards to its really discriminatory practices under the Canada Summer Jobs Program. So, the reality that our governments have been respecting constitutional rights and freedoms in Canada up until COVID, unfortunately, is not true. There's been a fight long before COVID, and COVID certainly has marched the government right into the houses of Canadians across the country, with the government telling you what to do in your house, where, who can you have over, whether you can leave your house or not, and if so, when. So anyway, but the Justice Centre has been fighting these cases. We continue to fight a number of non-COVID cases, and I will assure you that those cases are going to go past the current COVID litigation that, of course, the Justice Centre is heavily involved in as well.
Right. So you mentioned back in 2010, when the JCCF got started, some of the first kind of cases that you came across in litigation were abortion right cases, or at least abortion right and free speech on university campuses. Yeah. And you said something very interesting. Right. So I have two questions. First, this slide of, I don't have good terminology. I think it started with the quote unquote politically correct, and then slid into this new thing that we're seeing where it is harmful to have an opinion that is different than someone else. And that language is used. It could even be perceived as violent to disagree with someone about something like abortion rights. Did it kind of start back there at free speech on campus and abortion, and then just slide further and further forward to where we are now? And the other thing that you said that was really interesting is you said, sorry, I lost it. You said that point's gone. Anyway, let's start with the question at hand. Did it start with the free speech and the campuses?
Mm-hmm. I think we've really seen it there most starkly, where you literally had student governments and even university administrators say, "You're dangerous because you are expressing a view that this university doesn't hold." Not just that, your ideas are objectionable, but no, you are a dangerous person. You are a threat to the safety of this campus. And so we represented students on campus charged for misconduct, simply for putting forward an opinion the university administrators didn't approve of. You can look at that in the Wilson case at the University of Calgary, where we were successful in defending those students against those claims. But yeah, you can look at cases at Ryerson University, I think now Toronto Metropolitan, where the student union, with mandatory funding from the university, is telling the leaders of a men's rights club, including women who lead the men's rights club and want to have discussions about the issue of male suicidality, higher workplace injuries, depression, lower graduation rates. Well, because you're talking about those issues, you are a threat to the campus. And if you look at those concepts, you can see them playing out in even political discourse. I mean, back then it was these fringe ideas on, kind of strange campuses where you kind of just, okay, well, these are the fringe people over here. But now those fringe people happen to be running the country in political form, in their positions on regulatory boards. And so you see these same ideas being told to professional individuals, nurses, doctors, psychologists, saying, oh, you expressed a view on that? Well, that's not the narrative that we are promoting. You're not allowed to say that. You're dangerous to patients because of something you expressed an opinion on social media. And so, yeah, it's been over a decade where we've seen this trending in Canada, but the movement has been quite rapid, and there's clearly a connection between the two.
Yeah, that's so interesting. So in the case of men's rights on campus, and the language being used is, you are a danger to us because you're talking about men's rights. That is just so bonkers to me. And as far as I can tell, and I understand perhaps the psychology of the equation is maybe not where you spend the most time. I understand that you're a litigator, but psychologically speaking, it seems to be fear-based. Like, there's this fear of even talking about men's rights. Do you understand that? You've obviously spent time around it because you've been involved with the JCCF and litigation around those sorts of topics. Can you speak to the psychology of that sort of reaction? Because to me, it just doesn't make any sense.
Yeah, I think the appealing to an emotional and fear-based motivation in order to censor opponents has become the de facto position of those who do not embrace freedom. You see it in almost every scenario. Well, we can't allow this religious group to rent public space because that could cause some serious harm to someone who doesn't like the beliefs of that religious group. And it's there's not a rational connection there. It's just the fear of some harm. We can't allow unvaccinated Canadians on airplanes. They could do some damage to somebody somewhere somehow. Let's not base this on any science. Let's just throw this at the public and use that as the basis to now, push that group to do what we want them to do, or just to be absent from the public square and the public conversation. Let's other them. And yeah, the appealing to fear, rather than what in our Canadian history, which is rich with appeals to freedom, which is rich in trying to foster a democratic discourse in a multicultural, initially Canada was founded with You had the Protestant English communities, and then you had the Catholic French communities, and there was always been, we have differences, but we're going to learn how to live together. We're going to learn how to respect each other's rights. You want to have a Catholic school in Ontario? Fantastic. There's going to be a constitutional protection for that. You want to have a Protestant school in Quebec? This was the founding contract of Canada. And, you see Wilfrid Laurier talk about our understanding of ourselves as Canadians is an understanding that we are free. I mean, our home and native land was for God to keep it glorious and free. That is part of the Canada that we have as a history. But we have moved along with this, disordered discourse on college campuses away from the foundation of freedom. And you know what? I don't agree with what you're saying, but let me put this point to you and see how you respond to that. Like, that would be a college level discourse. But, there's always been an element of people in society that would rather appeal to raw power than to engage in an intellectual discussion. And that's always a dangerous trend. It's just, I was talking to an individual, for example, who worked with us, an experienced constitutional litigator, and he's like, this didn't just start in the 2000s. He recalls, an individual coming and speaking to Osgoode Hall Law School, and a particular law student was furious that this person, could speak to the law student body unmolested. And so they locked themselves in the sound booth and, turned all the microphones gains up and, scared everybody out of the room. This is like back in the late 60s, early 70s. And so, that is a human instinct to shut down your opponents at any cost. Is that an instinct that fosters a healthy and free democratic society? Not at all. But the further that gets up and the more that we allow our society to function like that, politically and legally, the more concerning the impact is on our really the health of our freedom and the health of our democracy.
Right. I remember the piece earlier that I had forgotten. You said you won a case, or the JCCF won a case that basically stated that the Charter applies to campus. The Charter of Rights and Freedoms applies to campus.
That's right. Yeah.
Why was that not originally assumed?
That is still a debate across Canada. The Justice Centre has won that case in Alberta. The Court of Appeal in British Columbia says the Charter does not apply on university campuses there. The Court of Appeal in Ontario says it doesn't apply on university campuses there. So there's a split in the jurisprudence. In fact, the Justice Centre has a case right now in British Columbia where we're defending a group of students called the Free Speech Club. And wouldn't you know, they hold free speech events where they allow people such as Ben Shapiro, Jordan Peterson, and in this case, they invited Andy Ngo, a journalist in the United States who covers Antifa, to come to the campus and have an event and speak about the dangers of Antifa violence. And guess what happened? Antifa threatened violence. And what was the university's response? We will not hold any controversial events on our campus. And so we are in the process of continuing a legal action against the University of British Columbia. And again, one of the main questions in that action is, how can an entity founded by the government of British Columbia, on land purchased by the government of British Columbia, that receives hundreds of millions of dollars every year from the government of British Columbia, from taxpayers in British Columbia, which activates government programs in British Columbia, which trains your required workforce, and which is populated on the board level with appointees, a number of appointees from the government of British Columbia. How can that institution not be a place where the Canadian Charter of Rights and Freedoms, including the protection for freedom of expression, applies? And so that is one of the questions in that case. Is the real issue there, and the final determination on that is going to have to wait until that case gets all the way to the Supreme Court of Canada, because there is this split in jurisprudence across the country. Sometimes a response to accusations that you're violating constitutional rights and freedoms, sometimes the response is, well, no, the Charter doesn't apply to us. And we've seen that even recently in some COVID cases, for example, in Alberta, where there's a transplant program put on by the government of Alberta, funded by the government of Alberta. The doctors are hired by Alberta Health Services, and they have a requirement that you have to be vaccinated with the COVID-19 shot in order to get a transplant. Well, you know what their response to the case that you're violating the Charter of Rights and Freedoms of unvaccinated people to access the healthcare our government provides? Well, they say, no, we're not government. And to this point, the Court of Appeal in Alberta said, no, those doctors are not subject to the Charter of Rights and Freedoms. And so those are, debates that go in Canadian society, and whether or not an entity, a government-funded, government-created, government-founded entity is subject to the Canadian Charter of Rights and Freedoms sometimes is a surprising question in some of these cases, and sometimes we get surprising answers even out of the courts.
That's kind of scary. Should it not matter who the patient is in question? And what I'm getting at is, if the patient is a Canadian citizen, I understand the argument about the doctor. I think it's a bit of a technicality, because the doctors are technically the doctors, if I remember correctly from previous episodes, are government employees, are they not?
They are fully funded by the
doctors
in Alberta.
The doctors are government employees, but not necessarily all of the nurses are government employees. The nurses might be private. I think
just kind of answer that, it's a legal technicality, because what you're saying is, well, you structured yourself as an employee or you structured yourself as a contractor. For example, you can look at a lawyer and say, well, you're a lawyer for this person. Are you an employee of that entity, or are you a contractor? And,
right.
Sometimes it varies. And so the technicality should not eat the principle, which says when a government is providing healthcare, they can't exclude 10%, 20% of the population based on a whim. They need to be able to justify their decisions under the charter. And that's the real rub. And I mean, to broaden this question out a little further, to show you how, it's a real question in Canadian society. Right now, one of the places in Canadian society where some of the most grotesque abuses of charter rights occur, but often hidden from the public eye, are on First Nations in Canada, where band members find themselves extremely discriminated against based on, whether they had an ancestor who was, a male non-status person or a female non-status person. Sometimes that's the defining feature on whether they get housing, benefits, the right to vote in band elections. And I took a case for a woman who was prohibited from running for band election because she's not legally married to her spouse. And so a discrimination against someone on the basis of marital status as to whether they can run for an election or not, clearly a violation of the Canadian Charter of Rights and Freedoms. And in response, the response to that is, well, sorry, we're a First Nation. We are self-governing. The charter doesn't apply to us.
Mm-hmm.
Well, so the idea that you can create an entire category of second-class Canadians who have no charter rights against their own government, again, these are very concerning legal issues, and it's not unimportant to ask the question and litigate it, hopefully to an appropriate answer, which says, no, there's no second-class Canadians in Canada, and your government entity must respect your charter rights, full stop.
Yeah, that seems like perhaps I'm ignorant because I don't understand, but that seems like a very bold gamble to say that the charter doesn't apply to us, because the charter includes a lot of very beneficial things that we as Canadians benefit from, or at least it should. So to throw that out in an argument and say, no, that doesn't apply to me, it feels like you're giving up a lot of other benefits for the sake of your argument.
Yeah, I think that, the expediency of government agencies in the present, sometimes when facing accountability for their own actions, to rely on and make arguments in law based on certain ideas, which could have far-reaching, damaging effects to society down the road, is of concern. And certainly it's a concern to see any government entity, whether it's a First Nations government or whether it's the federal government of Canada, come into court and essentially minimize the charter rights of its citizens. We saw a couple days ago the Federal Court of Appeal in regard to the hotel quarantine mandates. And you might recall that, there was a time when the federal government in all of its wisdom said that, you know what, if you're coming back to Canada, we don't want you to, go back to your own house and sit there for 2 weeks. We want you to go down to the Ritz-Carlton down here, pay your fee and stay with, a bunch of other random people that we're going to place in those hotels. And, for a few $1,000s, you'll support the hotel industry. And, somehow this is going to keep you safer from COVID and transmission. Just the logic was never there. The internal documents admit the logic was never there. We took the case to the federal court. In the federal court, the court said, well, clearly this is a restriction on people's liberty. They have a right to counsel. You got to tell these people that they have a right to call a lawyer. You can't just threaten to arrest them without that. And so we got that level, but then the judge said, well, and for the rest of it, the charter, this isn't really a violation. We're in a pandemic, don't you know? And so we went to the Federal Court of Appeal, which granted us an expedited hearing a year and a half ago. Well, that expedited hearing just occurred 2 days ago. And at the expedited hearing, the Federal Court of Appeal judges retired for an hour and a half and came back and said, we're not going to hear the charter issues in this case because after all, this was a long time ago and the law's not requiring people to quarantine in hotels. So we're going to call this case moot and exercise our discretion not to hear the case. Well, there's a lot of concern that causes for us as Canadians, as constitutional lawyers, when you see the idea that something is moot, and if I can unpack that term, the idea is like, oh, well, you're just asking an academic question. You want a hypothetical response. There's no factual circumstances where this issue was crystallized into an actual conflict. Well, in this case, the government forced thousands of Canadians at their own expense to lock themselves essentially in hotel rooms or be arrested. That is a real question. And whether that's violating the Charter of Rights and Freedoms in an unjustifiable way is a real question. And when you see federal court judges in response to the federal government's arguments come back and say, sorry, that was a long time ago. The law has changed. Let's move on. Well, that is a concerning implication for the charter rights and freedoms of Canadians. And so certainly the idea that the government can just stop abusing its citizens and therefore get away with it and avoid accountability in the courts for that is of concern. That'll be an issue that the Justice Centre looks to challenge higher, whether in that case or in other cases. But we've certainly seen courts and the governments argue strenuously, don't answer the constitutional questions that are raised by our past conduct, which clearly affected thousands and millions of Canadians in the cases of, the travel mandates. You couldn't get on a plane unless you're, jabbed with this, that, and the other. These are real questions that had real effects. People were prohibited from sitting by the bedside of their loved one when they're dying because the federal government wouldn't let them board transportation to get there. Mm-hmm. And right now we're fighting that issue in the Peckford Bernier et al. Cases in the federal court. And again, we're asking the same question of the Federal Court of Appeal. Will you hear this case and decide on an issue of great public importance? And will you hold the government to account under the Canadian Charter of Rights and Freedoms? Because our charter says, okay, government, if you want to limit the Charter of Rights and Freedoms of Canadians, you better demonstrate a justification that is reasonable in a free and democratic society. We're still looking to see that kind of accountability leveled on our governments.
Yeah, I have so many questions in regards to all of that. Let's start here, though. Do you believe that these cases are not being heard because they are, in the court's eyes, truly moot? Or do you think the courts, in some amount of cahoots with the current administration, are covering the backs of some of these people who made really, in my opinion, and this is my opinion, really poor decisions throughout the pandemic, like forcing people at their own expense to lock themselves in quarantine hotels? And if they didn't, I know a number of people who chose not to. They all received $6,000 fines. And so those are going to go to court at some point. But do you think it is a condition of trying to cover up and get away with what happened, or is it purely moot in the sense that it was a year and a half, 2 years ago now, and the court system is overburdened, which is another reality I know that we deal with? Where do you kind of see that question lie? How nefarious do you feel this is?
Well, I think I will stick to the facts, and I will, set it out this way. Almost every aspect of Canadian society in response to COVID and the narrative that was provided through public media, through experts, engaged across the board in restricting their own, but often imposing restrictions on other people's liberties. And the courts were not an exception to that. In fact, the courts imposed mask mandates and kept them in place longer than almost any other sector in public society. I recall arguing cases in June of 2022 with mask requirements being the first issue to be dealt with because there's somebody in the gallery that doesn't have a mask on, even though almost no place in society was still requiring masks. There's also the issue of vaccine mandates. Well, we know from some courts' own admission that they impose vaccine mandates on judges and court staff. I've argued cases in court where there's arguing a case that's saying, there's an unconstitutional gathering limit imposed. For example, you're not allowed to have people gather in this particular setting with more than X number of people. At the very same time, one of the only places in society where you will encounter a gathering limit was the courtroom. And so, given that background, it's from a human level, you could see why it would be difficult for a court asked to decide the justification for these kinds of measures imposed on society at large to be saying at one side, well, yes, I would like to evaluate the justification for this measure, when it appears that the courts themselves engaged in some knee-jerk decision-making that restricted the liberty of their own employees, their own judges, and members of the public. So that context is there. It's just a fact. It's a difficult area, I think, for anyone in society when there's been such a move to implement the narrative of, here is an existential crisis. We must all pull together. We must do everything we can to then encounter case after case after case that the Justice Center and some others bring where the facts do not in any way support the narrative that was pushed for the last 2 years. And that narrative came out in court notices. That narrative came out in the media. And, I think there's a real challenge that is going to face our judiciary, and that is facing our judiciary, to see, okay, what are we going to do about this? Well, finding a case is moot. Well, you don't have to, obviously you're not going to dive into the constitutional merits there. We've seen other cases in British Columbia where you have a decision that, well, this case is being brought as a judicial review rather than a statement of claim because Dr. Henry issued an order rather than the legislature passing a law, even though the effect of it was that everybody in the province had to do whatever Dr. Henry said, which is a law. That's not an order that would apply to a restaurant that has an unsafe practice, for example. But the court looks at that and says, well, because the order is issued in that fashion, we're not going to consider extra evidence. We don't need to consider this expert evidence that Mr. Moore and the Justice Center is bringing to the court. And so then you don't have the difficult decision to say, well, what about this expert that says it's just fine to go to church in this fashion and it's just as safe, if not safer, to go to church in person than it is to go to a workout class in a gym with 25 sweaty people, which is literally British Columbia prohibited worship services while at the same time allowing people to go to gyms. And here's the data. You had far more people in an 8-week period get COVID at a gym than in a year and a half at a church. But that's not the narrative that was pushed. For sure, that wasn't the narrative that is pushed. Or in other cases, which we've seen, you see courts essentially give almost blind deference to government public health officers and ignore the expert evidence of other public health officers who are now providing expert reports for us in those cases. And so rather than, dive into the evidence and say, well, clearly something doesn't make sense. If you're prohibiting outdoor gatherings and they're safe, and you're allowing indoor gatherings which are less safe, this isn't reasonable. This isn't a reasonable restriction of rights. But rather than seeing that kind of basic analysis, we're saying, well, who are the courts to second guess public health officers? Which, there's a responsibility of the Canadian courts to adjudicate questions under the Constitution and to determine whether the government has demonstrated a justification for what they've done in limiting freedoms. That standard, this is where the court's responsibility lies. But to date, we have yet to see judges apply that requirement with the rigorous approach that you would expect, even with perhaps a common sense approach.
Mm-hmm. So, do you have hope that you will get the courts to see some of these cases? I mean, obviously, the JCCF is constantly working at this. Is there a light at the end of the tunnel? Because I know there's a lot of people who would like to see some of these things properly litigated because they feel very confident that rights were unnecessarily taken away. I certainly feel that way. What do you like? Do you have? I guess you have hope for the work that's being done.
Absolutely. I think fundamentally, when there has been a rights violation, and when in the context of what we've seen take place in our society, in Canada, but also around the world, there probably is a tendency to circle the wagons a little bit. But the truth and the facts in these cases, and sometimes if it doesn't happen in one, it might happen in another. You expect there to be a breakthrough in the reasoning process. And, it's not uncommon in law that legal fights develop incrementally, and you find the bottom stair where there's a judge willing to identify, okay, here is a problem, we're not going to let that stand. And then you climb up another stair. So, for example, on the vaccine issue, there's many approaches, many views on vaccines, and a lot of evidence still coming out. And so I'm not going to dive in all the way on that. But I will say that, for example, the federal government made a considered decision to prohibit anyone who was fired on the basis of their COVID-19 vax status not to access employment insurance benefits, which they were entitled to. And you know what they called it? They called it misconduct. They said if you were fired on the basis of your inability, your choice, your religious beliefs that prevented you from getting this COVID shot, you're committing misconduct. That's just wrong at law. It's malicious. It's kicking unemployed Canadians while they're down in the middle of a pandemic, depriving them of subsistence income and a living. So this, I can tell it works me up a little bit. These are Canadians that have been hurt, and their ability to access legal counsel, by the way, is quite limited. And yet there's a administrative tribunal process that you have to go through. So the Justice Centre has come alongside Canadians. It's provided advice, and on some cases we're able to actually provide legal representation and go before the tribunal and say, excuse me, this individual who paid for EI premiums for 20, 30, 40 years, and you kicked him when he's down, not letting him access his benefits. You called it misconduct. His employer came to him and said, get the shot today or you're fired tomorrow. How is that misconduct? And so we're starting to see, okay, even on Ottawa, administrative tribunal members like, whoa, the federal government, Minister Qualtrough, who should know better than what she did, this is not misconduct. Look at this individual whose friends had to come around him to provide enough money for him to keep a room in Toronto for him to live. Otherwise, he would have been on the street. That is the kind of thing that we're going to continue to go after the federal government for. We're seeing wins there. We will keep building that up in that area. Quarantine hotel ticket cases. We're seeing prosecutors convinced to drop tickets all the time. We're going to find one of these decisions that goes to a trial, and we'll find a step to climb up on further. But we're dealing with a society, top to bottom, where people have participated in some sense in a narrative that is unsupportable. That narrative is falling. It's falling in the minds of Canadians every single day, and it will be falling in the minds of the judges that hear our cases and in the judges that hear the appeals of our cases. And, one of the first COVID cases is going to the Supreme Court right now. That's the Lewis case with the denial of the vax pass. There's an application for leave. The Supreme Court may or may not choose to hear that case. But in law, it's not over till it's over. And then there's always a responsibility that we as constitutional litigators in Canada have to, again, take the fight for rights and freedoms to the courts and in the most convincing way possible. Almost all of our cases, once they're going up the chain, they're supported by expert evidence. They're supported by many reams of affidavits. If you look at the Peckford-Bernier case, I think there's 15,000 pages of evidence just in that one matter. And almost a month straight of cross-examination where the government's justification for what they did was just non-existent, which, can bring me to the Public Order Emergencies Commission if you want to go there.
Yes, please.
Again,
let's segue.
Yeah, absolutely. So, your audience probably watched that with some interest. We had a convoy in Ottawa for 3 weeks, 4 weeks tops. And then we talked about it in ad nauseum hearings for 8 weeks and much more in written submissions. And what did we learn? Almost nothing from the federal government. They had a feeling, they had a belief that the law would enable them to do something that the law clearly, if you have any legal training at all, when an act cites the definition of another act about what is a public order emergency, what is a threat to the security of Canada, that is the definition. It cited it. But the Canadian government comes in and, Justin Trudeau, I have to tip my hat to him in some fashion. He did a pretty good job of speaking in a way that could obfuscate what was the clear issue. Was there or was there not a threat to the security of Canada as defined by statute that permits you to violate all of the rights and freedoms commensurate with the right to protest, your right to peaceful assembly, your right to freedom of association, your right to express yourselves. All of those things were just eviscerated by this decision, not to mention all of the attacks on the credibility of Canada in regard to banking institutions. So those issues we went all the way through. The Justice Centre had 7 lawyers that we were funding to go to that commission. The government has an army behind them as well. Their army seemed to be more in producing, a trained performance by the Prime Minister at the end than it was in producing the facts. And even their ability to provide documentation to the Canadian public. They were giving us documents during our cross-examination of Prime Minister Trudeau, documents that we'd been seeking for months. And that, it shows you the kind of transparency and accountability. We had a team behind us that were labeling us to ask the Prime Minister on the stand, a document that he gives us while he's on the stand, saying, this idea that you needed the Emergencies Act to compel tow trucks. Do you not have this email that you just disclosed to us 5 minutes ago that says the American government is offering you tow trucks? How do you answer that question? Why don't you answer that question to the Canadian public? Well, so we have that happening, but at the same time, the Justice Centre is also providing legal representation for 4 Canadians who participated in the Freedom Convoy. And this is in a legal case at the federal court level to say, okay, Public Order Emergencies Commission report is going to come out from Rouleau. There's no real meat to that, other than, the government should abide by what a commissioner says. But at a court level, there could be a court order finding a violation of the charter rights, finding that the Emergencies Act definition was not met. And so that matter is going to a hearing here at the end of March. And so looking forward to, again, putting some accountability back on the federal government. And of course, the role of accountability is the role that the federal court judges will take up.
Right. So, to my understanding, in order to enact this particular act, the sovereignty of Canada has to be under threat. Do you know how that is defined? Because that would be a very important piece to the puzzle.
Yeah, threats to the security of Canada is, I believe it's defined in the JCCF Act. And so the Emergencies Act references the definition in the JCCF Act as, this is what a threat to the security of Canada is. And that's very specific. And I mean, I don't have the terminology pulled up. It's a test. It's a clear legal test that's there. And it's not, will Wellington Street be closed? Because you might recall, you might recall that the Freedom Convoy participants worked incredibly collaboratively with the Ottawa Police. They cleared emergency lanes. Our lawyers that we provided to them were assisting them in these communications, and an agreement was reached with the city of Ottawa to move the trucks out of the residential areas and onto Wellington Street. And yes, Wellington Street is going to be cluttered with some trucks. I gotcha. That's a reality. Yep, that was going to happen. But what would be the concern? Well, to this day, Wellington Street is still closed in Ottawa. And they just came out with reports saying, it hasn't been catastrophic to traffic in Ottawa because they still closed it. Because Wellington Street was going to be closed and these trucks were still going to be parked in front of Parliament, possibly indefinitely, the Prime Minister decides that eyesore, or maybe a beautiful sign of Canadian freedom and liberty, depending on your perspective, would remain there. That's why you have to bring in war horses to run over grandmothers in their walkers who aren't leaving a protest zone in front of Parliament Hill. Like it almost beggars belief. But of course, that is the context that you're dealing with, and you can't have a straight answer to that. And I think the Canadian public have been denied a straight answer from their government. And the media has, by and large, seemed to be more interested in sideshows than they are in the main issue, which is, will this federal government respect the rights and freedoms of Canadians, the most basic of which is your right to protest?
Yeah, that seems to be an immensely important question, as far as I can tell. But, I don't know, maybe I'm mistaken. What about the freezing of bank accounts? Because I'm one of those individuals who saw what the truckers were doing and recognized that they were going to need help. Fuel is expensive. It was even more expensive back then than it is now. A lot of these guys were coming across the entire country. They were going to need support when they were there. So I said, hey, I think this is really, really cool because this is Canadians standing up for Canadians. And I believe in that. And so I chipped in $150 to the GoFundMe. And then, 3 or 4 days later, I woke up and was told by the federal government that I could have my bank account frozen for funding terrorism. Where does that stand?
Well, if we take our conversation back to the original discussion about accusations against your ideological opponents on a university campus, where you say, oh, they're so unsafe. You know what is something I did not see in those allegations? You're a terrorist because you believe in the rights of the unborn, or you're a terrorist because you believe that, that men's issue should be talked about. I didn't see that accusation. That is reaching so high, or in this case, so low, as low as it could possibly be. Yet, that is how the federal government treated an entirely peaceful protest, to the point where people are getting run down in the streets by the police, and they're still peaceful. I mean, hats off to the protesters that maintained that kind of composure, because I think that is almost superhuman. But to call it terrorism and then to unleash the totalitarian instincts of the financial institutions in Canada to freeze bank accounts. I mean, we saw quickly, of course, you saw GoFundMe, all of their principles washed out the window rapidly when there was a hint of something. So then they froze money, and they were going to confiscate your money. But, there was obviously legal fights pending in the back rooms. And so thankfully they ended up sending a lot of that back. But other money, the Ontario government acted ex parte. That means without any notice to the protesters, and just froze the money in bank accounts. So there's that money is still frozen in bank accounts, and the Ontario government wants that money.
That money is still frozen?
Yes, it's still frozen to this very day. And then there is an individual in Ottawa and a couple businesses represented by a lawyer by the name of Paul Champ, and they've created a class action. Now, I think there might be 3.5 million or so frozen in an account, thanks to the actions of the Ontario government in collusion with the federal government and banks. So that's frozen. But then this Ottawa group, a couple entities, has made a class action, which they're claiming against that 3.5 million. They're claiming $300 million in damage to the city of Ottawa residents for the alleged, interference caused by the peaceful Freedom Convoy. They're suing not only every protester who was in the city of Ottawa, they're also suing people who donated to the Freedom Convoy. And so that's a class action coming against peaceful protesters. There's a very dangerous precedent to be set there. And so the Justice Centre is helping to provide legal counsel there to fight against what is governments of Ontario and provinces and municipalities, and then private interests, funded enough to bring this quite bizarre class action. There's going to be a hearing on that in Ontario Superior Court here in the next couple of days, with a motion brought by a lawyer on behalf of the Freedom Convoy and on behalf of donors to the Freedom Convoy to strike that class action, or at least bring it down to an issue we can talk about. Did somebody honk a horn in front of your house all hours of the night and keep you up and cause you some form of damage? If you can prove that, maybe you have a claim against that person. But to say someone joining a peaceful protest it's a public nuisance is beyond the pale that the law can reach.
Well, what a terrifying precedent to set, that joining a public protest is now a scenario where you can get yourself sued.
And not
by peacefully assembling.
Right, not
which is a charter right,
hundreds of millions of dollars.
Yeah.
Right? Like the level of potential intimidation and chill on free speech, should the court allow something like this to go forward, is that could set a very, very dangerous precedent. And it's disconcerting to see members of the legal community push forward that kind of a claim against peaceful protesters. Again, if you want to target, I've seen protests where, a small group over here starts to do something violent and, smashes a window or burns a police car. If you want to go after those individuals, you won't find them at the Freedom Convoy in Ottawa, by the way. But, I could see a personal claim there. You saw the protests in Vancouver, for example, after they lost the Stanley Cup. There's a small group. Sometimes others joined. Find those people, make them liable for the damage they cause. But to sue a group and to say you as a group are liable for hundreds of millions of dollars in damages because you brought your grievances to the capital city of our country and sat there protesting and waving Canadian flags it's really surreal. And to think that case is still in the courts, we will look forward to hopefully seeing it stricken from the courts, or if not, hopefully restricted greatly.
Are you concerned that it won't be?
Well, I think you always, as a lawyer, you moderate your opinions and your optimism, and you put forward the very best arguments, and you're willing to meet any arguments that come against you. In particular, that case, I know we have excellent counsel on it, and looking forward to seeing the results there.
Yep, that's fair. So what about going forward? as we kind of wrap this up. What do you think Canadians are going to see in terms of some of these litigations over the next year? Law seems to take a very, very long time. But you spoke of that bottom step, right? Do you think we're going to see some of those bottom steps get cracked soon? And will that set a precedent for the next step, do you think? I'm trying to equip us with a little bit of hope going forward, you know?
Absolutely. Well, I mean, I'm hopeful in the sense that Canadians themselves have never been more alive to the issues of freedom. When I left Canada as a young guy going to study law, the idea of Canadian freedom and being a lawyer to fight for freedom, I mean, the Justice Center wasn't even formed at that point. And many, there's very few that were even thinking along the lines of defending freedom of speech in Canada. Now that is front of mind for probably close to half of the country. Regardless of where you fall on COVID, you're not going to be able to handle a medical profession, for example, that says you're not allowed to identify the reality that male and female exist as biological sex. Like that's right now, that is a case that we are dealing with at the BC College of Nurses and Physicians with Amy Ham. Jordan Peterson has brought more light to this issue of, just having a regulated profession dealing with public expression. So I do see that the Canadian public is becoming more alive to these issues. And hopefully that effect of the public will translate not only into pressure on politicians to change things. We have seen great change from a public that's risen up, if you will, including during the Freedom Convoy, and said, enough of these regulations, right? Like the public is not supporting the kind of regulations that they were under during COVID. And that's a good thing to see. Pressure on the politicians, but also often you do see legal decisions following a public consciousness which is raised. And so, even the influencing of the public consciousness on issues of freedom, on issues of rights, just on the facts of a narrative which is crumbling, those impacts will be seen. And I do think we will see court decisions that, at some point begin to grapple with the reality of the rights infringements that are at issue. Maybe it'll be dissents, maybe it'll be smaller decisions again that we build up on. But, one thing that I'm encouraged by is that there's thousands of Canadians who continue to support, for example, the work of the Justice Center. So we can have lawyers advocating for the rights of Canadians, including Canadians who are kicked off the EI rolls, to give them a voice in the courts. And so they're not lost on the Canadian system. And eventually, I do anticipate that those efforts will yield success. There's a lot more than COVID going on in this country. And yes, legal cases take a lot of time. This situation with Amy Ham in British Columbia, like the fundamental idea that you cannot even debate measures which recognize biological sex. I mean, every time you get on an airplane, every time you check in for a medical appointment, if your blood test, if it doesn't show male and female, I mean, like there's realities that happen that are there. And if our society is going to refuse to recognize realities, we are in a very dangerous position. Those issues will be litigated. How will the courts respond once they get out of the administrative tribunal process? I should mention, there's 4 expert witnesses that we've had on this, or will have on the stand for Amy Ham in British Columbia. All for, originally her sin was putting up a billboard, "I love J.K. Rowling." And then it spurred complaints about her social media advocating for sex-based women's rights. And these issues will continue to be litigated. The public conversation around them is sometimes just as important as what's going on in these particular tribunals. I mean, that case could go from that tribunal to the BC Supreme Court, and it could then be appealed to the BC Court of Appeal. It could be sent out at any time for a rehearing. It could go back up. The potential for cases to last years is a reality. But, again, I'm encouraged by the fact that Canadians are supporting those engaged in the fight for freedom. And, this is a long battle. The fight for freedom must be fought in every generation in some form or another. And when Canadians forget freedom, they're bound to lose it. And I think we had forgotten as a public consciousness the value of freedom. And I think we're regaining that understanding. And so from that, I'm encouraged. And of course, I'm grateful to be part of a legal team of, more than a dozen lawyers, paralegals, and many outside counsel that we work with to defend the rights of Canadians across the country every day.
I think that's a great last point to get to. So the JCCF supports Canadians. How can Canadians support the JCCF?
That's right. Well, the Justice Centre is a registered Canadian charity. We are dedicated to providing pro bono, that means free of any cost, representation to Canadians who are experiencing the violation of their rights and freedoms. We take cases where we seek to set a precedent for Canadians' freedoms. Sometimes, it's just valuable to push back against the government and not let them run over the rights of everyday Canadian citizens. And so it's our privilege to do that. We have hundreds of cases ongoing at any time, and we are grateful to the thousands of Canadians who donate at jccf.ca and who provide us with the funding that's necessary to push back against government overreach into the lives of Canadians.
Well, thank you, Mr. Moore. It's been a pleasure having you, and I really appreciate all of the insight that you gave us. That was really, really cool. So thank you for being here.
Well, thank you, Zach, and thanks for your questions, and thanks for all your audience tuning in. It's a great thing to see a Canadian podcast, which is, again, doing a very important work informing Canadians. And, as Canadians are informed, we become a population that won't be as easily manipulated, as easily coerced, and we will be able to hold our elected leaders to account. We will be able to move the public discourse to a place that respects the fact that Canada is a free society, and we will keep it that way.
Amen, brother. That's a great place to cut it. So thanks, everybody. Thank you for being here, and we will see you next time.
Thank you for listening to The Canadian Story. You can find us on Instagram and Twitter at The CAD Story. That's The CAD Story. If you enjoy this podcast, please share it with your friends and family. Let's work together to remind Canadians how great their country is.